Hello, I'm Adam Corbin, a partner at Michelmores. I'm hosting this series of podcasts released in the run-up to the Cereals Arable event at Thoresby Estate in Nottinghamshire on the 13th and 14th of June this year. These podcasts accompany a series of articles which you can access on our website. We'll be at the show with our stand, looking forward to meeting and speaking to friends old and new, hopefully over a cake, a gin or an ice cream. This time we're speaking about the challenges of incorporating new opportunities, particularly environmental ones, into agricultural tenancies. And I'm joined by Caroline Baines, Josie Edwards and Charles Courtney, who I'm now going to ask to introduce themselves. Caroline.
Hello, I'm a professional support lawyer for Michelmores agriculture team. I've specialised in non-contentious agriculture for over 30 years, dealing with a wide variety of different arrangements. My particular interest is in drafting clauses and documents for new complex issues, things like the new conservation covenants, biodiversity net gain, nutrient neutrality agreements, that sort of thing. And as part of my role, I'm responsible for drafting and updating Michelmores agricultural precedents which cover natural capital issues.
And Josie.
Thanks, Adam. I'm a partner in the agriculture team here at Michelmores. I've specialised in agricultural landlord and tenant work since qualifying in 2010. And having started out as a disputes lawyer, my practice has evolved in the past few years to be entirely non-contentious. I still do a lot of agricultural landlord and tenant work, but early stage advisory work, assisting parties in navigating their rights and obligations, and I do a lot of work looking at and drafting arrangements relating to the letting and management of land and restructuring those arrangements. And increasingly at the moment, that's meaning an awful lot of work and thought focused on natural capital, the management of land for environmental or biodiversity gains in future.
Thank you. Charles.
I'm a partner in the disputes team at Michelmores. I qualified as a barrister a number of years ago and a chancery barrister. My current expertise is in intellectual property and technology disputes. However, I also sit in the House of Lords as a crossbench peer, and in that capacity I was considerably involved in the passage recently of the Agriculture Act and the Environment Act. And specifically in the Environment Act, focused upon amending to make conservation covenants executable by deeds that Caroline now drafts regularly. But I'm also a farmer and land manager.
Hello, I'm Adam Corbin, a partner at Michelmores. I'm hosting this series of podcasts released in the run-up to the Cereals Arable event at Thoresby Estate in Nottinghamshire on the 13th and 14th of June this year. These podcasts accompany a series of articles which you can access on our website. We'll be at the show with our stand, looking forward to meeting and speaking to friends old and new, hopefully over a cake, a gin or an ice cream. This time we're speaking about the challenges of incorporating new opportunities, particularly environmental ones, into agricultural tenancies. And I'm joined by Caroline Baines, Josie Edwards and Charles Courtney, who I'm now going to ask to introduce themselves. Caroline.
Hello, I'm a professional support lawyer for Michelmores agriculture team. I've specialised in non-contentious agriculture for over 30 years, dealing with a wide variety of different arrangements. My particular interest is in drafting clauses and documents for new complex issues, things like the new conservation covenants, biodiversity net gain, nutrient neutrality agreements, that sort of thing. And as part of my role, I'm responsible for drafting and updating Michelmores agricultural precedents which cover natural capital issues.
And Josie.
Thanks, Adam. I'm a partner in the agriculture team here at Michelmores. I've specialised in agricultural landlord and tenant work since qualifying in 2010. And having started out as a disputes lawyer, my practice has evolved in the past few years to be entirely non-contentious. I still do a lot of agricultural landlord and tenant work, but early stage advisory work, assisting parties in navigating their rights and obligations, and I do a lot of work looking at and drafting arrangements relating to the letting and management of land and restructuring those arrangements. And increasingly at the moment, that's meaning an awful lot of work and thought focused on natural capital, the management of land for environmental or biodiversity gains in future.
Thank you. Charles.
I'm a partner in the disputes team at Michelmores. I qualified as a barrister a number of years ago and a chancery barrister. My current expertise is in intellectual property and technology disputes. However, I also sit in the House of Lords as a crossbench peer, and in that capacity, I was considerably involved in the passage recently of the Agriculture Act and the Environment Act. And specifically in the Environment Act, focused upon amending to make conservation covenants executable by deeds that Caroline now drafts regularly. But I'm also a farmer and land manager with an estate in Devon, which is a mixed arable and pasture estate with woodlands as well. And in that capacity, I chair a landlord and tenant working group across the Southwest and work quite closely with Exeter University to understand landlord and tenant issues. And we contributed a little bit to the work of Baroness Rock and her recent Rock report.
Thank you. So, Caroline, could you start us off by giving us an overview of the recent history of the agricultural tenanted sector?
Yes, of course. Well, as many people will know, until 1995, we had a very traditional regime governed by the Agricultural Holdings Act 1986, with many three-generation tenancies. Virtually everything was prescribed by statute. But at that stage, with numbers of AHA tenancies decreasing, we then saw effectively a deregulation of the tenanted sector and the introduction of farm business tenancies. When FBTs were introduced, they were heralded as a new, more commercial and sort of even-handed type of tenancy, where landlords and tenants would negotiate terms on a more equal footing. In most cases, however, the reality has turned out to be quite different. Gradually, landlords started imposing more and more restrictions, more and more controls over tenants, over everything, whether it's farming practices, diversification, subsidies, all sorts of things. And in particular, on the subsidies front, this has been a particularly contentious issue because of the way subsidies have developed. Some of them have been attached or linked to land, and the impact that they have had on the underlying capital value of the holding, which I know we're going to come back to later on. Interestingly, for ongoing Agricultural Holdings Act tenancies, we've now seen the government using legislation to rein landlords in. We've had a new set of regulations which were introduced in 2021 under the umbrella of the Agriculture Act, and these new regulations allow AHA tenants to refer to arbitration experts, restrictions preventing them claiming subsidies or fulfilling statutory obligations. So, if a landlord imposes restrictions on entering the holding into, say, countryside stewardship or the sustainable farming incentive element of ELMS, the tenant can take that restriction to an expert or arbitration and get it watered down or even moved. So that's an interesting development that's happened for AHA tenancies. It hasn't yet been rolled across to affect FBTs.
Charles, would you say that the changes in subsidies and the payment of subsidies have changed the landlord and tenant relationship?
I think there's been considerable change to the whole of farming, of which obviously landlord and tenant relationship, which I think amounts to about 30% of the farmed land in the country, is a huge part. The decrease in the basic payment that we're seeing at the moment, the rolling sort of 7-year decrease, is obviously stressing everybody in the industry, landlords and tenants alike. Those that are managing the land are seeing a decrease in the direct payments they're receiving. And gradually, obviously, we're beginning to see what is being introduced by DEFRA under the SFI, and everybody's waiting anxiously to see whether they qualify for these payments. With respect to the landlord and tenant relationship, there's been, I think, considerable more discussion amongst landlord and tenants as to how that they can benefit from this. But with the increased stresses on farm budgets, there's obviously considerable stress within the relationship as well, with respect to rental levels, to who gets to receive the new payments, and as to what kind of interventions within the land, what land management practices will qualify you for payments. And are those practices that are undertaken by the landlord, typically the planting of trees, for example, or are they practices that are undertaken by the tenant, for example, overwintering cover and such? And those discussions are causing both an increase in tension, I think, between landlords and tenants, but also an increase in opportunity for landlords and tenants to work together. And I think progressive landlord and tenants are taking this as an opportunity to really work on the relationship and really to see the changing mood of policy towards how we manage our land.
And how about society? Is there a societal shift in perception of farming and where food comes from?
Yes, there are so many sort of pressures and areas of focus. Obviously, climate change and biodiversity loss is at the top of many agendas. Many governments, many councils, many corporates are setting net zero agendas and net zero targets. And of course, really the only industry in the country that really has the capacity to sequester carbon is the land management industry, because land managers can obviously have interventions which actually provide a carbon sink. At the same time as that huge pressure, we've also obviously experienced COVID and the lockdowns and the considerable pressure on supply chains and imports that created. And then heaped on top of that, we now have the war in the Ukraine and obviously the loss for a considerable period of time of the huge productive capacity of the agricultural sector in Ukraine, which has put enormous pressure both on the supply of grain, but also obviously the cost of inputs. And so from all three of these areas, there is, a real focus on, are we self-sufficient in food? Are we producing our food in the best way for the environment? And how much are we paying for our food? And what's the impact of that on people's day-to-day quality of life? So there is considerable focus. I think farmers are seen in some areas as heroes and in other areas as the villains. And particularly if you look at sewage and water pollution and such, farmers are copping a fair bit of back for the way in which they treat their waterways. And so I don't think there's been a time in recent history that farming has been quite so much on the front pages. And bless Minette Batters, who is, I think, a fabulous spokesperson for the industry.
And Josie, there are other, well, perhaps there are opportunities rather than land use pressures.
Yeah, indeed. I think Charles's point about food security and the importance of our sector and the finite resource we have to deliver food security is a really key one. But we are also seeing pressures now as natural capital opportunities arise. And there is a clear need, for example, in the planning system now for land to be set aside to achieve biodiversity net gain. In parts of the country, nutrient neutrality is a huge issue. And that's increasing the pressures on already very squeezed land resource in this country. And of course, that's a new diversification opportunity, but diversification in our sector has been around for many years and are quite a standard consideration now for landlords managing let estates or let holdings. And the questions there arise as to what exactly tenants are able to do on their land and how much control landlords need to retain of that.
Charles, what do you think the modern landlord's attitude is to diversification?
I think landlords and tenants are hugely aware of the need to diversify. I think there is a concern about the long term viability of a purely agricultural business on land. And obviously, with the pressures on energy production, etc., as well as pressures on access and use of the countryside for biodiversity purposes, there are all sorts of different opportunities for the use of land. There's been a recent sort of parliamentary review showing that productivity in rural economies is 19% beneath the national average, i.e., there is a huge lag in the productivity of our countryside. And so landlords and tenants, I think, are looking at how we can possibly make up that difference and take advantage of potentially a great opportunity for an economic uplift if we do it right. But while doing that, we still need to provide food, as Josie has pointed out. We've still got to do the basic job of feeding the nation and providing a certain amount of food security.
Do you think that's making the landlord and tenant discussions easier or harder?
I think it's making them certainly more complicated. There's certainly a lot more to talk about. There are many more discussions about what you do with particular buildings on the land, what you do with particular areas of land that may not be the most productive land, but might have an opportunity for example, biodiversity net gain sites. So it presents a lot more to talk about, and that can be difficult because many landlords and tenants, particularly under the traditional scheme, kind of like not talking other than on the rent review period where there's a tried and trusted route to a rent. Throwing in all these other things gives you an awful lot more potentially to argue about, but also there's a lot more opportunity if you work together and collaboratively. And I think there does need to be a sea change in the relationship and how landlords and tenants look at what is effectively a common opportunity for their joint business to provide much needed public good and service.
I think that's so true, that mention that you make, Charles, of collaboration and how the relationship is starting to evolve and needs to continue to evolve. both sides are facing such huge change and uncertainty at the moment. The future we can crystal ball gaze to some extent, but only in quite a short-term way at the moment. We're talking, the next 3 to 4 years perhaps, but as we move forward, everybody is trying to navigate huge different pressures and uncertainties as they move forward. You've already mentioned all of the sort of input issues that farmers are facing, and also the flack that the agriculture sector seems to be getting from all different quarters at the moment. And that in some ways makes the conversation difficult because people are slightly defensive, but in other ways I think everybody in our sector has an opportunity to work together and navigate it in a collaborative, positive way and show that our sector can be a force for change and a force for good. And as you mentioned right at the start, the only sector really in our economy that can make a really positive difference.
So, Caroline, we're going to move to the nuts and bolts of this now a little bit. First of all, when considering new tenancy agreements, what are the broad topics that are usually up for negotiation?
Yes, well, there are sort of four main provisions which have to be addressed, which I'll run through. First of all, we have landlords' reservations. We very often see landlords accepting and reserving access to all natural capital schemes, which is a very wide exception and probably cuts across the tenant's freedom to claim the subsidy schemes. Not only subsidy schemes, but also private money arrangements. With reservations, we have to be careful because landlords cannot derogate from their grant. This is a legal principle which prevents landlords from granting a tenancy with one hand and then taking back essential rights with the other hand, which cut across the tenancy. So that's something which has to be borne in mind. But there's also the need for the reservation to fit with the other provisions relating to natural capital in the tenancy agreement. So secondly, we have tenants' covenants. Generally, we see covenants not to claim other subsidy schemes of various different types, not to enter BNG or nutrient neutrality agreements, not to enter conservation covenants, those sort of things, where these opportunities arise. The third area is break clauses, which the landlord tends to write in to give them the opportunity to break the tenancy for the whole or part of the term. We commonly see that imposed where landlords want to themselves enter into BNG or nutrient neutrality agreements or conservation covenants. An opportunity arises and they want that flexibility. And then finally, what mustn't lose sight of is that whatever is negotiated under those first three headings, there will be the effect of all those items on initial rent and rent review. The terms of the tenancy agreement are taken into account on rent review under the Agricultural Tenancies Act. So if restrictions are imposed, the rent level will reflect that position. Generally, the more restrictive the tenancy agreement, the lower the rent, which is likely to be determined on rent review. So they're not easy things to work a way through.
So, just to ask an obvious question, perhaps, why do landlords care whether or not the tenants are able to enter into arrangements for schemes or diversify on their holdings?
Well, I would say fundamentally that the starting point is that it affects the landlord's underlying capital value of the holding. If you have a tree planting commitment, a 40-year conservation covenant to maintain a particular BNG habitat, or an 80-year nutrient neutrality agreement, those items are likely, those arrangements are likely to affect the underlying capital value of the holding. Whereas if you've got a 3-year commitment under SFI or a 5-year countryside stewardship agreement, that is going to have little or no effect on the capital value. So the longer term arrangements are the ones that affect the capital value.
There's an interesting issue that certainly has been much discussed in Westminster, and that is that the most important asset in all of this is obviously the soil itself. And as between landlords and tenants, it's not really sure or certain who owns the soil. Obviously, at a certain depth, it belongs to the landlord, but it's the tenant who uses the soil for the annual productive capacity. And what we're all trying to do is obviously build the health and the vitality of the soil and the organic matter of the soil, which, if done well over a 20, 30-year period, will obviously increase the value of the natural capital within the farm. So is that landlords, and should the landlord be forcing the tenant to farm in a certain way? But actually, it's the tenant who, assuming he or she has a 5-year term, well, they're going to want the most productive 5 years they can have, which would arguably deplete that natural capital. So that tension, I think, is the core tension in this relationship, and finding ways within a negotiated tenancy to resolve that is one of the real challenges.
And the other big challenge or the other big factor, I should say, that has always traditionally had an impact is the tax regime, particularly the tax applying in relation to inheritance tax and agricultural property relief for landlords. When we're talking about diversification, if land use moves permanently out of agriculture, for example, into commercial use or equine, it will cease to qualify for APR. And so that's an incredibly valuable relief that would be potentially lost to landlords if they aren't able to use the umbrella of business property relief, which many aren't. And so that's another key reason, I think, why this sort of element of control has grown up over the years, with landlords wanting to know exactly what's going on the land that is let. And of course, that's been discussed a lot recently and is now the subject of a DEFRA and Treasury consultation about whether APR needs to be expanded in the context of these new environmental management agreements or the use of land for environmental services. Because of course, if you are truly managing land for biodiversity reasons or rewilding, etc., it is not going to be in agricultural use. And that's been a very key concern to the sector to date. So it's going to be interesting to see how that pans out, particularly in the context of APR being a relief that's sort of been in the firing line and discussed for a number of years as to how long it actually might last in its current form anyway.
You're right. Also, obviously, BPR as well, with a number of landlords seeking to be actively managing their estates. And does the provision of ecosystem services amount to an active business, or is it passive? And that can be really challenging. I think the other thing to bear in mind is often landlords will be managing a fairly contiguous set of tenanted farms, and the interrelationship between them is fairly key. And certainly you've seen, for example, the Duchy estates really working across the whole estate to try and get tenants to implement complementary management practices. So there's no point having one tenant planting a bunch of trees and the adjoining tenant and therefore sort of creating a biodiversity corridor, and then the adjoining tenant ploughing up to the corner of that or the side of that biodiversity corridor with acres of monocrop. So the landlord really needs to mediate and moderate between those various land uses across an entire catchment or land area, and that will hopefully uplift the value of the biodiversity or the ecosystem services that are being provided, but therefore requires the landlord to intervene in ways that the landlord hasn't in the past necessarily. And so that's creating a whole sort of new area of discussion and opportunity. But for those that, like, as Caroline described, like the autonomy of their tenanted rights, they don't necessarily want to be interfered with, particularly if you've had a sort of multi-generational occupation of a particular piece of land. Why should you do something just because your neighbours are doing it? And you might really feel like it's an infringement of your rights.
I think I'm certainly seeing in my practice as well, in terms of the instructions received, a definite move by landlords to take opportunities to perhaps, at least in the short to medium term, take land back in hand during this period of change and to sort of rationalise, reconsider the estate and how it all fits together. And as you say, to perhaps focus in a much more holistic way across your entire estate. There might be key areas of land, perhaps a riparian corridor, that they would like to have some control of moving forwards. And I'm definitely seeing more of that at the moment in terms of instructions received, which I hope will settle down a bit, and we will see perhaps more relets with very well considered collaborative tenancy agreement underpinning it.
Yeah, the two most damning statistics I always think in the agricultural tenancy sector is the fact that the average farm business tenancy is something like only 4 years in length, and there's no way that you can farm or manage land with a sustainable horizon if you're only looking at 4 years of occupation. And secondly, the average age of the tenants is 60 or 60 plus, and where are the new entrants? And so if land is being taken out of the tenanted sector and only granted on short-term tenancies, you really struggle to see how new people will get into sustainable sort of long-term land management practices and introduce new techniques, new knowledge, new understanding without a much greater appetite for landlords to let land to tenants.
Yeah, and to have any certainty to invest and to really take the sort of entrepreneurial spirit, it's that uncertainty is just a real block, I think, to innovation and change.
One of the things I could see that if you have a large area of land which would be ideal for a particular habitat or a project, in the context of tenancies, you might have an AHA tenancy on one area, a short FBT on another area, a 25-year FBT on another area. You can have a complete mishmash of different tenancy types. And that makes the practicalities of entering into or bringing together the farms into these a collaborative scheme quite challenging.
And I think, again, that underlines why it is so important to invest in that relationship and to be able to have very honest and open discussions between landlords and tenants and their advisors as to the different drivers and the different concerns that they have and pressures that they're facing.
So I asked Caroline a little bit about considering new tenancy agreements. Josie, how about existing agreements? What are the parameters for discussion, if indeed any discussions happen?
So there certainly are discussions that we're seeing, but of course they're more current event driven in terms of what opportunities might arise at any point in time, rather than trying to think about the future and crystal ball gaze. Because of course these agreements have already been drafted. The parties are stuck with the terms that might have been put in place in 1950, perhaps in the context of some AHA tenancies. You can imagine they say nothing about natural capital, and therefore they're not particularly useful. And so we're seeing, for example, in England at the moment, development land requiring off-site habitat for biodiversity net gain and nutrient neutrality, as I said earlier. And so that potentially is carrying significant capital value with it, allowing landlords to have discussions with tenants if there's an opportunity for both parties. But it's very much a commercial discussion rather than looking at the terms of the tenancy agreement, because we're finding that unsurprisingly, they don't have a huge amount of particularly useful things in there. There's some levers and some potential angles, but it's not as straightforward. So again, very much a commercial open discussion required to make progress.
I also imagine that rent reviews have been quite tricky over the last couple of years, given the huge fluctuations in commodity and input prices and just the crazy budgets that people are having to work to at the moment. We're used to a fair bit of flexibility, but the last year or two in particular have been so challenging. And how do you take that into account in a in a forward-looking rent review?
Okay, so Caroline, you draft and maintain a large number of precedent tenancy documents that are in common use across England and Wales. How are you approaching these challenges and these opportunities?
Well, what has changed, particularly in the last year or so, is that we now have, slightly longer than that, we now have an overarching need to prioritise environmental protection measures because of climate change, that pressure wasn't there 10 or 15 years ago to the same extent. We have the ESG agenda, which is spreading amongst companies. We're all facing increasing demand to show that we're addressing our carbon footprint, and the same applies to farm businesses. We will see more and more farm businesses having to demonstrate that their production is carbon neutral. So when it comes to new precedent agreements, rather than following the usual path of retaining wide control to the landlord, we're trying to encourage landlords and surveyors, their professional advisors, to consider the middle ground between landlord control and tenant freedom. What we're talking about is a collaborative approach, which Josie has mentioned, where landlord and tenant cooperate to prioritise environmental protection measures, where the tenant is able to claim appropriate subsidies to support the farming business. And at the same time, the landlord maintains a reasonable level of rent. The landlord can control matters affecting his underlying capital asset, and he's able to bring holdings together, as Charles mentioned, into landscape scale schemes and wider environmental projects. The challenge for me and for us drafting for the middle ground is the uncertainty of what the future holds, both for public subsidy schemes, credit schemes, and also for privately funded arrangements. As Josie mentioned, it's fairly straightforward to guess where we'll be in 5 years' time in terms of all these subsidies, but who knows what the carbon market will look like in 20 years' time. It is very, very difficult to anticipate where we'll be. So when you're drafting, you're looking at trying to be specific enough that the agreement makes sense, but not too specific that you're left with uncertainty when new arrangements arise that no one's seen before, that we've not anticipated to the same extent.
I think, Caroline, you really point to an important element, which is there's so much anxiety in the marketplace around what will be available, and no one wants to miss an opportunity to make back some of that lost BPS payment, for example. And so everybody's anxious that they don't tie themselves to some commitment that may not be viable in the future, or tie themselves to a commitment that prevents them from doing something else. Equally, I think people are concerned that they're committing too early to certain things that may not actually be practical. So it's such a tremendous time of uncertainty, which really doesn't help the industry.
And it doesn't help the drafting, as Caroline said, how you actually, if you've got heads of terms for a 20-year FBT in front of you, how do you actually sensibly draft for that? And as Caroline's mentioned, we're trying to find a middle ground. And there's sort of a number of possible approaches or possible ways to do it that we've been discussing. For example, perhaps ensuring that tenants are given access to all public money and publicly funded schemes like SFI, ELMS, etc., but giving landlords control over privately funded arrangements. But again, you can see how very quickly we might have schemes, potentially landscape recovery schemes, for example, where blended finance is quite common, and that distinction between public and private money becomes less clear cut. Length of tenancy would be another potential factor you could base it on. Tenants given complete freedom to enter shorter term arrangements and schemes that are less likely to affect the capital value of the landlord's underlying asset. Landlords given control over access and decisions about longer term schemes. But again, something that could be done relatively quickly during the term of a 10-year FBT, like a woodland planting scheme, would have very long-term impacts on the capital value, even if it can be done and dusted in terms of the creation and establishment of that woodland during the tenancy scheme. So again, there's sort of a nuance there that really does need to be considered. And then perhaps another possible approach is to think about giving tenants freedom to enter schemes or arrangements that only affect the let holding and doesn't impact on the wider estate or adjoining land, but giving landlords more control or flexibility in relation to schemes that might cover a wider area and require collaboration either between neighbouring tenants on a estate or neighbouring landowners. But any one of those alone potentially feels like too blunt an instrument to focus on. And a sort of more nuanced approach needs to be considered. But that then, of course, raises drafting complexities.
I could see some landlords just hearing about these complexities and throwing up their hands and saying, I'm not going down that route at all. But I think whereas in the past, landlords have had little to lose by retaining control, the difference this time round is that landlords do have quite a lot to lose in terms of rent review, in terms with protection of the environment, the bigger aim that we mustn't lose sight of.
Yeah, and I think I've mentioned it more than once already in this discussion today. I think collaboration and working together is going to be key. And perhaps one sort of useful approach, and it's one that we've seen, for many years, is for landlords to, for any decisions about entering schemes, to require landlords' consent, but for that to be qualified and for consent not to be unreasonably withheld, and to perhaps focus more on having a dispute resolution mechanism if the parties aren't able to come together and agree the path forward at the appropriate time, that there is a clear, straightforward means of referring that decision-making process and that any dispute that's arisen to a suitable expert to try and break through the deadlock.
Yeah, you're right, Josie, in that regard. I mean, what may be a reasonable refusal of consent now, by 2028, when ELMS has fully been rolled out and everything is supposedly clear as crystal, it may be unreasonable to refuse consent at that stage. And with a changing landscape, I think the availability of this flexibility within the landlord and tenant relationship is potentially a strength of it.
Yeah, and as you say, Charles, ELMS has not been rolled out yet, and it's totally in its infancy. And we're talking about England, and it's more progressed in England than it is in Wales. And tenants in Wales are facing really similar concerns. And there's going to be particular things in Wales, like a 10% target for woodland and tree cover on farms before you even qualify to obtain the sustainable farming payment. And so that's all still out for consultation and being considered and developed. And so it really is just such uncertain times, as we've already flagged.
And I think when you're drafting, all this uncertainty comes back to the point, the fundamentals of what you're going to grant. So when you're looking at new tenancies, how long a term are you going to grant? How much freedom are you going to give the tenant? How is the collaboration going to work? What mechanisms are you going to have to bring the parties together to discuss these issues? It's just a very complex area, though, because there are just so many factors coming in at the same time.
Great, thank you very much. Charles, I'm going to give you the opportunity to finish on either a positive or a negative note now. So, in your opinion, do these new opportunities represent a future for the tenanted sector, or are they going to just drive landlords to take more land back in hand and take more control?
I think on the negative side, I think we are probably, as Josie referenced, seeing landlords being a little more reticent to grant tenancies than perhaps they were 15 years ago, when there was perhaps quite a bit of enthusiasm about the flexibility of FBTs and the opportunities they provided. But on a positive note, I think, as I referenced, the UK is fairly unique in the health and vibrancy of its agricultural tenanted sector and the extent of it. We do have a really strong agricultural sector, and a lot of that is down to the variety of interests that are at play, the variety of skill sets that come into it. And that's very much down to the flexibility of the landlord and tenant relationship. And I think in an uncertain time, and with so much potential opportunity, as we said right at the start, in land management to provide alternative energy sources, to feed the land, to provide clean water and sequester carbon, etc., I think our landlord and tenant sector actually has quite a bright future, and I certainly hope so.
How about you, Josie? Are you feeling positive or negative?
I'm hopeful, and I would totally reiterate that remark that I certainly hope that as things bed down, the tenanted sector continues to be an incredibly important cornerstone of our sector, and tenants are given an opportunity to be involved in these new opportunities that arise, and everybody can have a sensible